The anti-gunners and their friends on the federal bench are trying to engage in civil disobedience against the NYSERDA versus Bruen decision, but it's not going to work for a whole host of reasons. Nevertheless, I'm going to bring to your attention the sorts of nonsense that I'm seeing out there so we can nip it in the bud with why what they're attempting to do simply is not right under the U.S. Constitution and beyond. Today, we're going to talk about a judge in Mississippi, an Obama appointee, and his theory about why he's not capable of applying the Second Amendment as understood by the U.S. Supreme Court in Bruen. We'll talk about this nonsense when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and to bear arms. All right, folks, you're not going to believe this. Actually, you probably will believe this, but that's okay. I'm flagging it for you so we can nip it in the bud. So we have a federal judge in Mississippi, a judge appointed to the federal bench by President Barack Obama. And what is he saying in dealing with the Second Amendment and his ability to apply it to modern-day controversies involving gun control laws? Well, Judge Carlton Reeves in Mississippi wrote an order last week which got picked up by, among others, CNN. And what did CNN talk about when it discussed the order from Judge Reeves? Well, it turns out that Judge Reeves basically indicated that he doesn't feel capable or competent enough to apply the Second Amendment as it's to be interpreted properly under the history, the text, the history, and the tradition of the Second Amendment, which is what the U.S. Supreme Court explained. Now, of course, if I will tell you this, if an attorney made some of these complaints that I'm going to read to you from Judge Reeves, if he made such a thing to me, I might even fire him for gross incompetence. But let's focus specifically on what Judge Reeves says, and then I'm going to point out to you why it's just an absurd statement. I can't believe he actually wrote this in a court order. So Judge Reeves specifically said, in an opinion dealing with I believe this is a felon in possession law. So basically, just step back for a second. Let's remind ourselves that Justice Clarence Thomas in NYSERDA versus Bruen pointed out that the only way a modern-day gun control law can stand scrutiny under the Second Amendment is if there is a historical analog back in 1791 consistent with the modern-day gun control law. Now, a historical analogy, is used specifically to demonstrate that the modern-day gun control law being discussed is, quote, consistent with the nation's historical tradition of firearms regulation. Can't be an outlier. It can't be a needle in the haystack. It has to be consistent with the history and tradition of regulating firearms in America based in 1791. Now, Judge Reeves, reading this and reading NYSERDA versus Bruen, basically threw up his hands apparently and said, oh my God, I can't figure this out. This is too hard. That's my interpretation of what he's saying here, because this is what he says, quote, this court is not a trained historian, close quote. Okay. Well, actually, that's not even true, but we're going to get to that in a second. What else does Judge Reeves say? He says the justices, quote, the justices of the Supreme Court, as distinguished as they may be, are not trained historians. Okay, that's not even true, but we're going to get to that in a second. And Judge Reeves should know better. Do you know why Judge Reeves should know better? Because when he became a federal judge, he put up his hand and he swore, presumably on a Bible, but he swore on something, that he was going to uphold, among other things, American law, and specifically he was going to uphold the United States Constitution. That very same document, including the Second Amendment right to keep and bear arms, so he already took an oath that he was going to abide by it and follow it and read it and apply it to be a federal judge in America. And yet now, after he's been a judge, he now somehow feigns ignorance that he doesn't know how all this stuff works. Of course, we know that's simply not true. Let me tell you why. Okay, it's not that hard. Judges in courts, what is their job? Okay, if you're a plumber, you keep the pipes working in homes and buildings. That's your job. If you're an electrician, you keep the electricity running. If you're a doctor, you keep people alive through the practice of medicine. What does a judge do? I'll tell you what a judge does. Their job is to apply the law. Going back to the three branches of government. Congress passes the law, enacts the law. The president executes the law, enforces the law. And the courts interpret the law. Your job as a federal judge, as any judge in fact, is to interpret the law by applying the law, interpreting the law and applying it. It's your job. Now, our laws are reflected in the Constitution and on statute books. Many of these books are quite old. I mean, the United States Constitution is over 200 years old. So it's an old document, but your job is to abide by it and to interpret it. It's your job as a judge. Okay? And unless that Constitution's been amended or repealed or something, you got to follow it. You got to interpret it. And the way to interpret, of course, is you look at the text, you read the Constitution, that's step one. And beyond that, you can look at the history associated with the Constitution to understand what the parties intended to do. Now, this is not like a super secret, unusual process for judges, because even when judges interpret, let's say, contracts between you and your plumber or between you or a partner, what does the judge do? They read the contract that was written usually many, many years earlier, and they say, what does the contract mean? What does the text of the contract mean? And what do the parties intend? Same thing with the Constitution. What did the Constitution say as written, the text? And what did the parties, meaning the Founding Fathers, mean when they adopted it? Very basic job of the judge. Nothing complicated here. Now, let's go on to say that when you interpret the Constitution, any kind of old text, right, use history. This does not require any special expertise outside of the practice of law or being a judge. Let's look, and I just pulled this up quickly, okay? I just pulled this up quickly. Now, I know the reality is Judge Reeves probably doesn't like the Second Amendment, is my guess, and he certainly doesn't like the Second Amendment written the way it was written as interpreted by the U.S. Supreme Court in Bruen, because it's very hard for modern-day gun control laws to stay on the books because they're unconstitutional and violate rights. And he probably doesn't like that outcome. And because he doesn't like the outcome, he's upset that he has to follow a process that's going to give rise to an outcome he doesn't like, which is to strike down a bunch of illegal, unconstitutional gun laws. But I digress. Let's look at what the U.S. Supreme Court, without trained historians, right? They didn't hire trained historians. They interpreted the law and they looked at the history. This is what the U.S. Supreme Court judges, just like Judge Reeves, have done in the past, right? We know that when they interpreted the Second Amendment in the Heller case in 2008, do you know how many pages of history in the Heller decision there were? Over 60 pages of history in the Heller decision alone. There were dozens and dozens of pages of history in NYSERPA versus Bruen. The Supreme Court certainly seemed capable and comfortable with using history to interpret the meaning of the right to keep and bear arms, because they used literally dozens and dozens and dozens of pages to do so. But this is not unusual. It's not specific or unique to the Second Amendment. Let's talk about some of those other aspects of the Bill of Rights. We know, and this is just my quick back of the napkin stuff, right? I'm sure there's a lot more out there. You could probably write massive amounts of scholarship on what I'm about to say, but I'm just going to give you a taste. 1947, the United States Supreme Court decided a case called Everson versus Board of Education. In that 1947 case, they spent 9 pages discussing the history and the meaning of the First Amendment's Establishment Clause, which says you can't establish a religion, a national religion in America. Okay? In 1940, in Cantwell versus Connecticut, the U.S. Supreme Court spent 8 pages analyzing the First Amendment's Free Exercise Clause, including the history. In Weeks versus the United States, the Fourth Amendment talked about 10 pages with a little bit of historical review. Miranda versus Arizona talked a little bit about history. So there's plenty of examples of historical analysis out there when you interpret the Bill of Rights. Because again, the way to understand any document is you read the text and then you try to understand what the parties meant when they adopted it. And who are the parties that adopted the Bill of Rights and the Constitution, including the Second Amendment? That's the Founding Fathers. So you're looking at the history of what they intended makes a lot of sense, which is why every single law student in America reads, for example, the Federalist Papers and often the Anti-Federalist Papers, the historical documents that go along with what was the purpose of the United States Constitution. This is what judges do. The fact that Judge Reeves is pretending not to understand this, to me, again, is simply nonsense and an excuse to engage in civil disobedience to try to ignore the Second Amendment and apply it in modern day life. Now beyond this, of course, it's very interesting that Judge Reeves feels the need to take this position as opposed to the other ways that the anti-gunners wanted to interpret the Second Amendment. So Judge Reeves has taken the position that he's not capable of reading the text of the Second Amendment and applying the historical standard that you do for every other aspect of the Bill of Rights, because he says he's not a historian, but he is a lawyer and judge that applies historical documents and reads them all the time. In contrast, what's interesting about the anti-gunners, and I don't know if Judge Reeves specifically is an anti-gunner, but I'm guessing I know, but I don't know for a fact. Here's what's interesting. Isn't it interesting that the anti-gunners across America wanted judges whose job it is to interpret old text to instead interpret the Second Amendment by engaging in cost-benefit analysis, tiers of scrutiny, balancing test, where they would balance the statistical benefits of gun ownership against the statistical benefits of so-called gun laws, gun control laws. So here you have a judge that says he's not capable of applying history of the Second Amendment, which judges do every day. But in contrast, the anti-gun community wanted judges who have mostly no experience when it comes to numbers, with empirical data, with statistics, with any kind of math, right? Many of them are terrible at math, which is why they went to law school. So somehow it's perfectly fine for judges to balance away our rights, which they've been doing for over a decade, with tiers of scrutiny, which again is really just balancing the good and the bad of guns using statisticians and empirical research, which courts and judges are 100% worse at than interpreting history. In fact, the United States Supreme Court in Bruen specifically made this observation that courts are much more comfortable with interpreting older text, and the history associated with older text is their job, in contrast with trying to become experts in the world of statistics and interpreting the Second Amendment with a statistical view or mathematical view about the good and the bad of gun ownership. So the Supreme Court specifically addressed this. So if you think judges are bad historians, well, they're even worse at statistics and econometric analysis and the like. But beyond that, there's even some other crazy anti-gun theories out there, one of which is called corpus linguistics, which we'll talk about later. You've never even heard of corpus linguistics, and you're lucky because of that. But basically, corpus linguistics is a fancy Latin phrase for taking a corpus, which is the body of words, which is linguistics, right? Corpus is body, and linguistics is words. And basically taking a body of words and doing a word search to come up with a bunch of words to help you interpret, among other things, the Second Amendment. Now, I've debunked corpus linguistics in a major article in a law review, which we'll talk about in another video. But all you need to know for the purposes here is the anti-gun community was interested in using corpus linguistics to reinterpret the Second Amendment in a way that was very, very bad for your rights. That's what you need to know. And I can assure you that the understanding of corpus linguistics, which is a very esoteric, crazy kind of academic theory out there, judges are far more familiar with interpreting history and the text of a document like the Constitution than they are in the detailed so-called scientific, or not scientific, you can debate that proposition, analysis and data collection involving with corpus linguistics, which again, in my view, was a way for the anti-gunners to try to read out the right to keep and bear arms. So, to close, the bottom line is this. This is another example of a judge in America that's upset, I presume, with the NYSERPA versus Bruen decision. He is looking for a way to get around it. He has raised the prospect of hiring historians appointed by the court to help him interpret the U.S. Constitution. And let me be clear. If you are a federal judge that swore an oath to uphold the United States Constitution, and now you tell us that you're not capable of applying the Constitution as it was written and as the history books teach you was what it was supposed to mean and how to apply it, then you should resign and get yourself off the federal bench because you're not capable of doing your job. And my last point here is I want to note that history is mission critical to the entire American legal system for two main reasons. The first is we in the Anglosphere, meaning we in the United States and the English common law, all embrace a body of law called common law. Common law is distinguished from civil law, which is really more of a French system where everything is written down verbatim and you follow what's written in civil law. But common law is, cases get decided and then you look back at older cases as precedent. And then you apply those precedents in modern day cases. So the entire American legal system is basically based on this notion of common law, with judges looking back in time at prior cases, defining those as precedents, and applying those old precedents today in modern day controversies, which is exactly what the U.S. Supreme Court is asking courts to do in the Second Amendment context, is to look at 1791 precedents and laws to help interpret the meaning of the Second Amendment. So if you are not capable of looking back in time and analyzing precedents and applying it today, you're really not capable of being a judge as I see it, because our entire American system is based on the common law notion of following old ancient precedents. And if you're not capable of going back in time and applying old precedents today, then again, you can't be a judge in America as I see it. And last but not least, keep in mind you have such a thing called legislative history. Did you hear that word, Judge Reeves? History. Legislative history is the history that goes into statutes that are enacted, the legislation that's enacted by Congress, the legislation that's enacted by the legislature of, let's say, the Commonwealth of Massachusetts. Well, the history associated with that legislation is, guess what? History. So if you're not capable of understanding the history associated with, like, the Second Amendment, presumably you're also not capable of understanding the history associated with, let's say, a statute enacted by Congress or a statute enacted by the Commonwealth of Massachusetts. Again, probably not a good sign for your future as a judge and your ability to do your job. That's just my opinion. Okay, hope you learned a little bit something. I know this is a little bit of a geeky topic today, but an important one because we're going to keep our eyes on where judges and other people that don't seem on board with applying the Second Amendment as written, see where they're going and try to nip any of these nonsense kind of arguments and theories in the bud. That's what we hope to do here at the Four Boxes Diner. So again, hope you learned something. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.